Welcome. Thank you for joining me for this edition of the Austin Prep Presents virtual webinar series. I'm Jennifer Hodgden. I'm the Director of Alumni Relations and Giving at Austin Prep. And today I'm lucky enough to be joined by attorney Rob Peterson from the class of 2004. It's been a little while since Rob and I worked together. Just about a year ago, Rob was here on campus with us with Career Day. So welcome, Rob.
Thank you, Jen. Thank you and Austin for having me here tonight.
Yeah, glad you could be here. So Rob is going to be sharing with us the basics of estate planning. So he's going to take us through wills and trusts and designating beneficiaries. But before we get started, I'm going to invite Rob to give a little bit of background about himself, tell us about his journey from Austin Prep to being a successful attorney, maybe in a nutshell. You don't have to go into all the details, but we can't wait to hear from you.
Okay, yeah, Jen, thanks again. Rob Peterson, Austin Prep class of 2004. I'm currently an attorney over in Wilmington, where I work alongside my father, who was also a 1975 Austin Prep graduate. I graduated from New England School of Law in 2012. And right when I got out of law school, I actually went to work in the Massachusetts State House. I worked for Representative Ken Gordon. And then thereafter, I transitioned into private practice alongside my father and into our family business. During my time in law school, I had a bunch of different legal avenues I was pursuing. Two of the ones I found most fulfilling were I worked for the Massachusetts Attorney General's office in the Enterprise Major Crimes Division, and I also did some work in the Massachusetts Probate and Family Courts. I currently reside in Wilmington with my wife Kelly and our two young daughters, Hadley and Sloan. We actually have a third daughter on the way. We're due in May. Yeah, another girl. I'm going to be busy when they're teenagers. And we have two labs, Grace and Marley. And in my spare time, I like to ski, golf, play hockey. And I'm also involved in many different charitable organizations. I'm a member of the Wilmington Rotary Club. I chair the Wilmington Rotary Scholarship Fund. I'm involved in different business groups. I belong to the BNI Strategic Partners, which is a business referral group. And I also donate my time to many other charitable organizations.
Do you have time to sleep?
I do. Not with the little kids, so.
Well, so before we move into a slide deck that Rob has prepared for us, I just want to let our audience know that you're welcome to use the Q&A feature at any point if you'd like to ask questions throughout all of this program. And right now, I'm going to turn it over to Rob, and we're going to take a closer look at the ins and outs of estate planning. So Rob, go right ahead.
Here we go. Start sharing this screen here. All right. Again, so this evening we're going to just go through estate planning. It's just going to be, again, the basics of estate planning. And we're going to move on to the program overview. So today's program will allow us to touch on estate planning basics that you need to consider when thinking about your estate planning matters. The program will go over intestacy laws in Massachusetts and thereafter transition to some basic estate planning tools such as wills, powers of attorney, healthcare proxy, HIPAA releases, and living wills. We will also briefly touch upon trusts, but due to the complexity of that issue, I ask if you have any specific questions relative to the same, that you direct those questions to me individually, and perhaps we can connect outside of this meeting here tonight. Lastly, we're going to go over identifying probate and non-probate assets and the steps you can take to effectively manage the same, designated beneficiaries, so on and so forth on that front. I know I'll have some questions over some terminology I'm going to use, and I'll try to define those as we move on here throughout. But if you have any questions or concerns, please feel free to shoot Jen or I a question via the Q&A feature of this online chat. I invite anyone with more specific questions to reach out to me after the program via email or cell phone. I'll have my information teed up at the end of these slides. And I'd be more than happy to discuss the same with you at length. Again, with any estate planning matters, we're going to go over the basics, but when it gets down to the nitty gritty of things, each person's unique and each family's unique and everyone has a unique situation. So sometimes any question that you might have, if it's not as generic or it's more specific, I'd be more than happy to touch base with you outside of this meeting here tonight. And again, for a plethora of reasons, not the least being if they don't want anyone divulging any attorney-client privilege over an online chat here. So So first, again, we're going to go over intestacy. We're going to go over wills and trusts, again, the POAs, healthcare proxy, HIPAA release, trust, a brief overview, identifying your probate for non-probate property, and then what's next? What steps do you need to take? And then we'll move into some Q&A. Intestacy, what is that? So in Massachusetts, if you die without having a will, without having created a will, you die intestate. And in Massachusetts, Chapter 190B, Section 2101 provides that any part of a decedent's estate that is not sufficiently disposed of by a last will and testament, we'll use will as we go out here throughout this slide, will pass via intestate succession to the decedent's heirs. What does that mean? There's a lot of legal terms we're throwing around here. It simply means that in the absence of you having a will, the state's going to decide what happens to your property. And that's subject to a plethora of different scenarios and situations, which we're going to go over. The next couple slides will kind of go through what happens if you die intestate with a spouse, if you die intestate without a spouse, and then there will be two more charts that we can kind of go over more in length relative to that. So intestate distribution, if you have a surviving spouse. So if you have a surviving spouse, the surviving spouse receives the entire estate if there is no parent or descendant of the decedent living, or if all the decedent's surviving descendants are also descendants of the surviving spouse, i.e. all of the decedents, we'll start at the most linear line here, all their children are also children of the surviving spouse. Then that surviving spouse also survives a descendant, they're going to take everything. If the decedent is survived by a parent but has no descendants, the surviving spouse receives the first $200,000 of the estate plus 3/4 of the balance of the intestate estate, with the remaining 1/4 going to, again, the parent or the living descendants of that parent. If all the decedent's surviving descendants are also descendants of the surviving spouse, and the surviving spouse has one or more surviving descendants who are not descendants of the decedent, the surviving spouse receives the first $100,000 plus 1/2 of the balance of the intestate estate. And lastly, if one or more of the decedent's surviving descendants are not descendants of the surviving spouse will receive the first $100,000 plus 1/2 of the balance of the intestate estate. So basically, as you can see what we're going on here, if you don't have a will, which you should, and especially you should have, anyone watching this, or if you're talking to friends and family in the coming days, months, if you know anyone that has a mixed family, it's especially important to create a will, because these are what you're going to be left with if you don't. And again, it goes with surviving spouse, and that people are going to take different shares if they have, children from another marriage, children from outside of wedlock, so on and so forth. Intestate distribution, again, you die without a will and you do not have a surviving spouse. If the decedent leaves descendants, then living but no spouse, the descendants receive the entire intestate estate per capita at each generation. So I'm going to go over what that means after we go through these next couple bullet points. If the decedent did not leave a spouse or descendants, the decedent's parents receive the entire intestate estate in equal shares or all to the survivor thereof, so the survivor of the parents. If the decedent did not leave descendants, a spouse, or parents, the descendants of the decedent's parents receive the intestate estate per capita at each generation. Again, we'll go over what per capita each generation means. Or if the descendant did not leave descendants, a spouse, parents, or descendants of the decedent's parents, the next of kin in equal degree receive the intestate estate in equal shares. So it gets very confusing, as you can see, if you don't have a will, and Massachusetts statutory scheme kind of accounts for all this. And I can tell you, I get this a lot. What happens if all of that fails? Well, if all that fails, the government's getting all your money, all your property. They get everything. If you don't have any heirs, decedents, if you can't follow that line of intestate succession, it would be a public administration. Different counties have only certain individuals who can do those administrations, and then your property will ultimately wind up with, again, the Commonwealth or the soldier's home, and we'll go through all that in the next charts coming up. I'll give this chart here, and again, you'll be able to access this after this program. It just goes through exactly what I said. It more aligns if the decedent is survived by a spouse and children, spouse with no children, it goes so on and so forth down. And if you read left to right, the scenario on the left and the result of who the intestate estate is going to pass to is going to be on the right. And then really quick before we pop off of this and go to the next slide. So per capita each generation, it means the heirs of the same generation will receive the same amount. The estate is divided into equal shares of the generation closest to the deceased person with surviving heirs. So the best way I can illustrate this is person A passes away and they have relative or heirs B, C, and D. C and D, B, C, and D each get 1/3 the share of A's estate. But say B had passed away, then B's heirs go down, each get 1/6 of that share. So that's what per capita each generation means. So again, we're talking about here, this all will come into play if you die in Massachusetts without having previously executed a will. And then again, I always include this for reference. So the degree of kinship, you'll see the decedent's going to be about 3/4 of the way down the page in the middle. Your lineal descendants will be your children, grandchildren, great-grandchild, so on and so forth. And if you die without children, it goes back up to your parents, then over to brothers and sisters, niece, nephews, you go left. If you die with no siblings, you go up to grandparents, so on and so forth. While it looks like a very confusing roadmap, it's easy to follow if you ever find yourself in this position. And again, if this chart were to fail, then you would be dealing with the public administration. And I can say that my 8 years of practice, I've only seen 2 of them. And it's funny, one of the ones that I did see where we couldn't locate any heirs, it was a friend had brought the probate estate to my office. When you filed it, when we filed it at Middlesex County, where we kicked it off to a public administrator who thereafter filed it at Middlesex County, heirs seemed to come out of the woodwork. There are actually people that hang out at probate and estate courts in the Commonwealth, and their job is to solely find these people who are heirs of estates that are filed by public administrators. They take a fee. It's a very interesting business model, to say the least. All right, so we'll move on to the last will and testament. Again, Mass law states that any person over the age of 18 that is mentally competent can make a last will and testament. It must be in writing and signed by the testator, which is the person making the will, and at least 2 competent witnesses must attest to the fact that the testator has signed the will as his or her free act and deed. Again, in Massachusetts, wills can be, and people always say, well, why isn't my will 1 page? Well, a will can be 1 page, but you want to account for, if you're going to go about the measures of making a will, you want to account for anything that might need to be in that will, requisite appointments, division of property, so on and so forth. And we'll flush some of those matters out as we move along here tonight.
A question here for you, Rob. Someone was wondering about the ideal age to start estate planning, given that you had mentioned a person over 18 can make a last will and testament. So do you have any recommendations on that? Like, is it best to start, say, after you have your first job with benefits and you're starting to accumulate, whether it's a 401k or stocks or things of that nature?
Yeah, so you can look at it 1 of 2 ways. So your estate planning can start as early as the age of 18, because when you turn 18, when you reach the age of majority, and I think parents often overlook this. Say if your child goes off to college and you have a 19-year-old away, if you're no longer their parent, that child should have in place some basic estate planning documents or some basic documents that would fall within the guise of an estate plan, healthcare proxy, power of attorney. So you can make those actions for that the child who's, again, they're not a minor anymore, but they're going to need, they should have those in place. But as far as a will, it's a very fluid situation, because someone who can have somebody can have different assets at age 18 than they could have at age 30, or someone could come into assets at age 19 and then need to take a look at their estate plan. So it really goes on a person by person basis.
Okay, and one other question that just came up, does jointly owned property such as real estate, automobiles, bank accounts, does that need a will if you have something that's jointly owned?
No, so we'll touch on that at the, as we are going to touch on that at the later end of the program here tonight. So if you have jointly held property, if there's a payable on death or a transfer on death beneficiary in any property you own, that is not estate property. So as far as getting that into the hands of the next owner, again, that'll pass outside of probate. However, it gets really tricky, and we're not going to get into too much tax discussion here tonight, but if anything you have an incident of control over can be part of your quote unquote taxable estate. But as far as it getting subject to the probate court, jointly held property, real estate held by husband and wife as tenants by the entirety, real estate held as joint tenants, that is not probate property. It would not be subject to the terms and provisions of a will. Again, I think we go on. Types of devises. So there are many types of devises somebody or theoretically could have in a will. You have a specific devise. I devise specific bank account, specific real estate, etc. to John Smith, or it's a specific piece of property, tangible, personal, real, to a specific person. You have a general devise or a general bequest as a gift of a specific amount made to a specific person. This is considered a general bequest because only the value of the property is relevant, not the source to which it's coming from. You typically see these in a last will and testament where someone says, I leave $25,000 to my grandson, John Smith. And demonstrative devise, also known as a demonstrative gift. It's a monetary amount to be paid from an account certain or designated source. If the specific source or designated account are insufficient to fund those requests, the devise can be made payable from the general funds of the estate. So from other funds or residual funds, or the general funds that aren't otherwise specifically bequeathed in the last will and testament. As for a more practical standpoint, when someone's doing estate planning, and again, I would say for about 80% of the individuals that come into my office, you're going to see the examples of devises are going to be, you're going to see a monetary devise. I want to leave $100,000 to my niece, Joan Smith, and the rest residue remainder to my other nephews, A, B, C, and D, in equal share alike. I also see, and Jen and I were talking about this earlier, a lot of charitable devises. It seems to be a bigger trend, especially with those individuals who either don't have children or their children predeceased them. Charitable devises, again, are a thing that can be specifically crafted into your estate plan. And again, it's a thing that's becoming more prevalent, at least in my practice. And again, especially for those people who either have accumulated wealth or they have, their children may have predeceased them, or they have a specific affinity for any sort of charitable cause or institution. And again, the most common thing I see people coming in, especially if they have, if they have 3 or 4 children, they talk to all their children, they get along with all their children. You'll see the class, the class devise, or some people like to call it a class gift, that divides everything to a class of persons equally, i.e., to my children equally and share alike. It means you have 3 kids, they're each getting, the 1/3 of the estate, and that's very typical of your more common estate plans. And also, what I see as well is for people who are grandparents, they like to leave, a certain monetary amount to some of their grandkids, and then leave the rest residue and remainder to the remainder of their grandkids. That's a very specific or a very common devise that we see in estate planning here at my office. Also, just as a point of clarification too, and you'll see this whether you talk to myself or if you talk to other real estate practitioners, the MUPC, which is the Massachusetts Uniform Probate Code, allows for reference to a memorandum in a will. So you can leave reference to, I might leave my my personal representative. Again, these terms we're going to go over in a few seconds. A memorandum relative to how I want my tangible personal property devised. The MUPC, with its creation, allows for that to be an enforceable letter. It doesn't need to be created at the time of your will. However, you can say, I will leave a memorandum, and I wish that my personal representative abide by the terms and conditions of that memorandum when devising, especially when you're talking about class gifts to my children and share alike. That memorandum can be most helpful if you have any specific article of personal tangible property that you want to go to one of your heirs over another. If jewelry, it's a good way to do it. If you go to Massachusetts continuing legal education classes, when they talk about this, having specific divisors of tangible personal property in your will often creates more problems than it solves. If you say, I leave my diamond necklace to my niece Joan, well, if you had got rid of that before you pass away and it's in the will, it can cause a lot of confusion for your niece Joan who comes looking for that diamond necklace when you pass away. So therefore, if you keep a memorandum, it's more of a fluid situation relative to your tangible personal property. And again, it is recognized by the MUPC. And you can all you have to do is just cite that in your will, and that'll give it effect.
One other question that just came up that might sort of fall into this area, or you may answer it in just a few minutes, but can you amend a will, an existing will, or do you have to rewrite or write a new one?
No, so you can do what's called a codicil. A codicil is an amendment to a will. It's the same. I mean, when you talk about certain kind of trust, you can always amend trust amendment. But when you want to amend a will, the easiest, it's a rather simple fix. If you want to amend Section 5, is a document you pull up. However, if you're using the same attorney, I can often tell you that it's easier for that attorney and less confusing if you, so say if someone does a will with me in 2016, they came back in 2020, we have all those documents on hand. So we usually just make an edit to the will itself. And then in that will, it'll say that it is hereby revoking all of the previously made wills, and then take it from there. But I have had many a situation where someone comes in, they had paid a small fortune for estate planning. They want to, with a different attorney, whether the attorney's out of practice or they're just not using them anymore, you can do what's called a codicil. Massachusetts does recognize those. And at the end of the day, when you have to file a probate, there is actually a specific section asking you if you have a will, what the date was, when it was, if the original is in the possession of the court, and if there's any codicils to that will, which would be a will amendment. All right. Last will and testament: appointments and common terms to be adjusted in a will. Again, like I said earlier, theoretically, you could have a will that is one page. I give all my property to A, B, C, and D. However, what you typically see, and even the most basic will, accounts for situations that, while they might not be pervasively common, they're common enough that practitioners choose to add that language to their will. Some of the things you'll see throughout wills of any size, shape, form, or an estate plan of any size or fashion is going to be appointment of a personal representative. Some of you might be familiar with the term executor, executrix. The MUPC did away with this type of language and adopted the term personal representative. So the personal representative is going to be the person in charge with overseeing your estate if it ever should have to go to probate. So that's what a personal representative is, and they should always be identified within the last will and testament. You should always identify the trustee if you're utilizing a testamentary trust, and we'll also talk about that later on. Some folks choose to, even if they have the most basic of estate plans, they choose to name a trustee of any trust that might be created for any minor beneficiaries they might have in their will. A guardian, if your testator has any minor children. If you have minor children, the person would seek appointment of a guardianship over a minor child, i.e. if mom and dad both pass away, leaving a minor children under the age of 18, the court would look to who the parent would list as the guardian in the last will and testament. The same thing with a conservator. Mom and dad pass away in that terrible situation. The minor children will be left. You would have to have a guardian of their person appointed and a conservator of their property. A caveat, and again, the court would look to, did mom and dad, have they requested anybody, and they would lend deference to whoever you listed in the property, in the last will and testament. This becomes a really a bigger issue. And again, these are things you don't like to talk about in estate planning in general. People don't like to talk about, but if your families don't get along, or if you don't want, I've unfortunately people come out, I don't want my mom and dad to have custody of my kids. I don't want my sister, so on and so forth. So when you name those persons, the court will lend deference to whoever you do list as guardian conservator in your last will and testament. And when they go to make those appointments in the probate and family court, again, that'll be brought on the paperwork that you were named in the last will and testament. And one thing on a conservator, many times I get people ask me a question. Well, I named a conservator, but I also have a trust. Does my conservator oversee my trust? Well, no, the trustee of the trust oversees the trust property. But the reason you want to take a belt and suspenders approach to all estate planning is you want to name a conservator in case your children under the age of 18 come into any property and it's not by way of your estate, i.e., mom and dad unfortunately pass away, and then the grandparents pass away, no estate plan, and then the kids all of a sudden inherit money. You want to make sure that the conservator would have access over that money, but if mom and dad had any sort of trust set up, it would go in there. So it's a belt and suspenders approach. Make sure that you appoint a guardian conservator when you have minor children to ensure that their best interests will be looked at with if anything should ever happen in the case where both mom and dad pass away. Other items to be addressed in the will. Again, there are many things to be addressed, but I just wanted to pick out a few just so everyone could have an idea when they go in to visit an estate planning practitioner. A personal representative to act without court supervision. You always, or I would say, it is prudent to have unsupervised administration. That means the personal representative can act, again, without court supervision. If your will is silent to that fact, unsupervised or supervised, you can petition the court for an unsupervised administration. But probate and family courts will always be looking for a will that says that the testator wanted unsupervised administration, i.e., less involvement of the court, which means less cost to the estate. And at the end of the end game should always be making sure any assets you passed away with go to your heirs and devisees. And there should be less court involvement because, as you can imagine, more court involvement, higher legal bills, because when you have attorneys doing this stuff, it's not cheap, and they have to charge hourly. And especially with probate and family court, in order to get stuff done in there, you have to actually go there. So you're billing. You can imagine what those bills could be. Removal of bond requirement for a personal representative. Unless the will states that the personal representative does not have to post surety on their bond, a court can actually make you requirement. A court can actually require that you post one. One caveat to that: even if you die intestate without a will, if all your heirs agree that a personal representative can serve without having posted bond, obviously the court will allow it. Or if in the case where you pass away without a will, and for some reason I can't think of what it would be, it's not addressed in there that you can serve without surety on your bond. All the heirs and devisees can assent to the filing of the probate, and thereafter you wouldn't have to post bond. And the question always comes up, why would I want to remove bond? That's another cost going against your estate. In bonds in Massachusetts can get pretty hefty, and it goes by the value of the estate. So the more money you have to be probated, the more expensive that bond's going to be. Power of sale. While there are many terms that dictate how a PR can act, and if you look at a standard will out of my office, there'll be, you'll have a plethora of things that they can do in addition to what's authorized to them by statute. Power of sale is pervasively and most commonly used, and what that means is they can sell any and all estate property, again, owned by the decedent and subject to the will. When does this come into play? This comes into play most specifically with real estate. If you pass away and you have a will and there's no power of sale, a subsequent probate filing is necessary, and the subsequent probate filing is what's called a license to sell real estate. That adds a lot of money onto your probate administration. So probate administration, which is already an expensive thing in and of itself, if you have to file a license to sell, you actually have to get the court has to authorize you to sell it to a third party. So if you don't have if you have a power of sale, as soon as your PR is appointed in probate court, so when you petition the probate court, you get appointed, the PR is allowed under Massachusetts Land Court guidelines and conveyancing standards to actually sell in accordance with that power of sale. So basically what you would do if you had a power of sale, any deed out from the estate, so if the decedent died owning real property, would state the term is that you sell in accordance with power of a sale conferred in the will of John Smith, Middlesex or Suffolk Probate and Family Court docket number so-and-so in every other power. However, if you don't have a power of sale, it's another arduous process to which you have to submit your purchase and sale agreement. You have to submit other, they call them MPC forms for sale of real estate, and it adds time and it adds money onto your estate administration costs. Some questions I got before this program, and what we see, kind of what people are always asking, especially if they're coming in during a life change, whether it be a will, a partner passes away, spouse passes away. A divorce and or annulment both serve to revoke any dispositions you made in a will to a former spouse. So that's how that works. And I had a question about that. In a divorce and or annulment will also serve to revoke any revocable disposition to a former spouse, including any trust you have, beneficiary designations, and life insurance policies and retirement accounts. However, that is not without caveat. You have to look at the fine print, as that can be limited by the express terms of the government instrument, which would be any sort of life insurance policy, and also a court order or a contract relating to the division of the marital estate, i.e. your separation agreement. So the general rule is the divorce or annulment will serve to revoke any revocable disposition or dispositions in a will. However, you have to look to those things against the express term of any contract governing, like your divorce, separation agreement, so on and so forth. And how do I go about revoking a prior will? I revoke a prior will two ways. You execute a subsequent will that expressly revokes the last will and testament. I've printed out a will in front of me right here. I, John Smith of Boston, Suffolk County, Massachusetts, make this my last will and testament, consisting of 12 pages, and hereby revoke any and all previous wills and codicils hereby executed by me. So that standard language is going to be in there. That's going to, again, by your execution of a subsequent will, that act alone will revoke anything you had previously done. And also any intentional act, revocatory act, such as tearing up your old will, burning your old will, that's going to be considered to revoke it.
Rob, we have a question that comes on the heels of, just came in on the heels of the power of sale, regarding the power of sale. If kids are the inheritors of the property, and if both parents are deceased, should their wills include a power of sale?
Yeah, so the will should always include a power of sale, but if you have minor children, you have to make sure that you're guarding those minor children, whether it be trust work done outside of your will as your estate planning process, or the bare minimum, we always suggest at least a testamentary trust within your will. Testamentary trust is a little more, I guess you could call it cost effective for estate planning purposes, because that's actually just a trust created in your will. And it only operates if you die or if you pass away with minor children. But you should always have that power of sale, because even if you have minor children, the personal representative should always have that authority to deal with your estate as they deem fit. And if your estate, again, goes to your minor children, that power of sale, they might need that money from the sale of your house to fund the care, education, so on and so forth. So it's always a good idea to have in there, again, but the person the PR can only use it because they have a fiduciary duty to the heirs and devisees of the estate. So they can only, again, use it if it's in the best interest to sell any property which would be devised or needed to get to be dealt with under your last will and testament. So the answer, that was the long answer. The short answer is yes, even if you have minor children, mom and dad pass away owning joint real estate, the power of sale and the will should still always be there to give your personal representative the tools they need to adequately administer your estate and to make sure that your children are best taken care of.
Okay. Another one that just came up, should digital assets be part of a will? Should you have a power of attorney to access digital accounts?
Yep. So that's a great question. So I'm going to go over that on power of attorney, but we can address that right now. So in our power of attorney, we do allow for digital assets to be accessed, and it also allows for the digital assets to be accessed by the personal representative. But that I'll leave it at there because it's a slippery slope to kind of wade through on what you actually can access of a decedent. But having that language in your last will and testament, again, will allow you the tools needed to most effectively administer the estate. Correct. Okay. Omitted heirs, another question we always get. If you intend to omit or to disinherit any heir of yours, you must specifically and unequivocally do so in your will. This happens a lot if someone has an estranged child, and if you have 4 children, you don't talk to one of them, and you want to disinherit them. You want to, again, specifically and unequivocally do so in your will, because there is a very good chance if you don't do so, say if you just don't account for them and you left it at that, when they challenged your will, or if they challenged your will, the judge would lend deference to, well, why didn't they specifically omit them in the will? And that heir, why, you're not a D by, you're an heir, but you're not a D by Z, but you're also not specifically omitted. So the sample omitted heir clause, which I'm going to read, but this is what should be in your will. Again, if you're looking to specifically disinherit somebody or omit an heir, it should read something along the lines of, insofar as I may have failed to provide in this will for any of my heirs presumptive, such failure is intentional and not occasioned by accident or mistake. Further, I specifically exclude from this my last will and testament, my son, John Smith, of Reading, Middlesex County, Massachusetts. It is my intention that the aforementioned person or any person not specifically named in this last will and testament, including the issue of the said John Smith, shall take anything hereunder. Basically, what that does is, if you ever get into a situation where there's a will contest, and I've been involved in plenty. This gives the judge looks at that, and the judge says, well, it's pretty clear they didn't want you to inherit anything from here. So that kind of, when your attorney's arguing why child A, B, and C are getting the money and child D is not, well, child D, who's John Smith in this case, is very specifically omitted from the will. And then again, that would have to, there's a plethora of arguments I've seen attorneys make why they were omitted, undue influence, all that good stuff. But again, that's your attorney's job to ensure that when they drafted it, they were of sound mind, and they were doing it, again, under no undue pressure. Power of attorney. A durable power of attorney is a written instrument by which you, who is known as the principal, designated someone you trust, such as your spouse, another family member, a friend, or a professional, as your attorney in fact or your agent. Your attorney in fact is authorized to perform certain acts on your behalf, and they can perform those acts just as you would. The powers give your attorney in fact, the powers you give to your attorney in fact under a durable power of attorney will be operable upon execution. So it's a very powerful document. So basically, a real life scenario is you come to my office tomorrow, January 27, 2021, you execute a durable power of attorney as the principal. Your agent can actually take that document and act on your behalf on January 27th, 2021, immediately upon execution thereof. So they could take it over to a Bank of America and open up a bank account on your behalf. So that's why we always say, in view of that significant authority, you have to make sure there's a degree of trust here, right? You have to trust the person you're going to be appointing as your durable power of attorney. And again, to touch on something we talked about earlier, I have to say that if a parent sends their 18, 19-year-old son or daughter in, they always want to come in. Well, I'll be there with them. Well, you can't be here with them. You can drive them here, but you can't sit in the meeting, because you have to make sure they're execute that as a free act indeed. They're not under any undue influence. And again, the effect of the durable power of attorney be effective immediately can, for practical circumstances, can help parents if their kids go to school, whether it be far away, or if they want to make sure that they can manage their child's affairs, again, if they're over the age of 18. But the overarching principle here is this is a very powerful document that should not be taken lightly. Another point, again, I want to touch on is what happens if you don't have a POA. Real life example. I actually, a little sad twist to the story, but I'm just wrapping up a guardianship conservator case I was working on. The gentleman ended up passing away, but my client's significant other They were unmarried. He did not have a POA, did not have a healthcare proxy, suffered a massive stroke. He thereafter suffered, I think, 3 or 4 more strokes and even in the hospital. He was in a vegetative state. He was actually at Leahy Hospital, and there's nothing they could do until we had a guardian appointed over his person and a conservator for his property. If he had a POA, a power of attorney, or a healthcare proxy, we could have moved those things along, more efficiently and without delay, but he didn't. So he had a petition the probate and family court. Thank goodness this was done pre-COVID, so it was, while not while not speedy, it was a little more faster than it is now. Now it's nearly impossible to get anything done, even on an emergency basis, due to the court closures, limited court personnel, limited allowance into courts. Zoom, they're doing all these hearings by Zoom. So it's just something to think of. And I always tell people, especially relative to the next two things we're going to talk about, powers of attorney and healthcare proxy. These are effectively the things you'll be glad you had, and you're always saying, well, I should do them, and then unfortunately when people need them, they just haven't taken the steps necessary to get those in place. And again, doing them now will save some pain now, and again, I say pain because this is just not a comfortable thing to think of. Doing a will, talking about death, talking about incapacity, it's not naturally, it's not comfortable for one to want to think about it. But if you get ahead of it and you make these steps now, what you should think of is you're making it easier on your loved ones should something happen to you. And I always use the my example of the stroke victim, because he didn't. You never plan on that kind of stuff. In life can be pretty cruel and throw some curveballs at you. So if you have the right planning in place, again, you're going to save yourself significant time, heartache for your loved ones who are going to have to go through the process of getting appointed guardian conservator over your guardian of your person, conservator of your property, and it just makes the whole process move along smoothly. And if nothing else, it allows your decisions, your healthcare decisions, your personal decisions to be made, that much faster. If you have all this stuff in hand, you can hand it to the hospital, your doctor, and say, here you go. They executed this on December of 2019. I'm ready to go. What decisions do we need to make? Another question we get relative to powers of attorney, because again, you can have limited powers of attorney. Some folks out there might be familiar with this. The limited powers of attorney are very common for such things such as a real estate conveyance. If you're selling real property, you don't want to go to a closing. You don't want to do certain aspects of your own dealings relative to that real estate. You enter into a limited POA with an attorney or a third party to allow them to do that on your behalf. Again, durable power of attorney is kind of a more all-encompassing, allow them to take more actions. And relative to what some folks ask, well, what if I've heard these things called springing power of attorneys. And what springing power of attorneys are is they spring into place if A, B, or C happens. Well, you typically like to lead people away from those or advise people against those, because what you're creating is another threshold to which somebody has to overcome in order for that power of attorney to be operable. So if you say, well, I only want this operable upon my incapacity, well, then in that case, you have to be judged to be incompetent, or you have to be adjudged to be not able to make those decisions. And while in some scenarios that might be clear cut, not in all scenarios. So again, you're talking about a document and a power of attorney that it comes with it an inherent trust. So in my opinion, durable is the way to go here. It's immediately operable and allows that person to make the requisite decisions for you if and when they are needed. Healthcare proxy is a document by which you designate an individual to make decisions concerning your healthcare in the event you're not able to make those decisions on yourself. And a question we're undeniably going to get here is, well, I sign those every time I go in for a surgery. Do I need another one? Well, if you sign a healthcare proxy with a estate planning professional, they're a lot more encompassing than what you're going to sign at. I'm not knocking or not disparaging, a Mass General, Brigham and Women's, Leahy. They do great things, but a healthcare proxy drafted by an estate planning professional will be more encompassing relative to the specific person and what that healthcare agent can do on the principal's behalf. So again, it doesn't, if you go in for a surgery and execute a healthcare proxy, that's fine. However, having the healthcare proxy in hand comes in, is more for those scenarios, again, that you don't count for. So estate planning is all about accounting for, the unknown, or what might happen. So if you execute a healthcare proxy, again, you're allowing the person you know, like, and trust, of the person who you're going to allow to be your healthcare agent, that authority, to act on your behalf without having to introduce any intermediary for that power. I.e., they don't have to go to court to be appointed guardian to make a healthcare decision on your behalf. If, for instance, you're the person who has God forbid, has a stroke, and someone needs to make those decisions on your behalf. And again, the Massachusetts Healthcare Proxy Statute allows for the avoidance of medical guardianships if one has a validly executed healthcare proxy. So, like I said, if you have a healthcare proxy, you don't need a medical guardianship, and they can make those decisions on your behalf without any sort of court intervenence.
Question about that, Rob.
Yeah.
Is this something, so for instance, if you know you're going to be going into the hospital, you know you're going to be having bypass surgery or some sort of potentially life-altering procedure, is this something that you would take your healthcare proxy that your own attorney you worked with, you'd take that and have that there with you should, something happen during the procedure or thereafter?
Correct. You take that with you, you hand it in. So when you're doing your admittance paperwork and they give you one, you just say, I already have one. It was executed by my attorney. It's all in accordance with Massachusetts law. You hand it to them, and then you'll be all set.
Okay, great. Thank you.
HIPAA release. So obviously, I'm not going to go over if you're unfamiliar what HIPAA is. So it protects your healthcare information. And why execute HIPAA release, or why talk about HIPAA release, or why include HIPAA language in POAs and healthcare proxies? Well, the reason is we want your power of attorney, and we want your healthcare proxy to have access to your protected health information. So if you codify that in the instrument, in the healthcare proxy, in your power of attorney, you're taking away any uncertainties that they might have relative to what's in your healthcare file, and you're giving them access to it. Practically speaking, we add that language into our power of attorneys and our healthcare proxies, and we also have our clients execute a subsequent HIPAA release. Basically, why do we do that? We do that in case the person is competent to make their own healthcare decisions, but for some reason they want their husband, their wife, their kids to be able to have access to their healthcare information, even if they remain competent and able to make their own decisions. It's a very typical scenario that they will also want somebody else to have access to it, so they can advise or help them in that, in having access to that information. So again, that's something to think of. If you have a dated estate plan, make sure you go through to see if those HIPAA language is in there. And if it's not in there, you can supplement it by either creating a new one or just getting a HIPAA release and have it tied to any pre-existing power of attorney or healthcare proxy. Living will. So a living will is just a document that expresses any individual's desire to refuse or to be refused any extraordinary medical treatment or being kept alive by artificial or mechanical means that result in merely a painful prolongation of life, or to serve only to prolong the process of dying. Basically, these are also commonly referred to DNRs, do not necessitate. In Massachusetts, they're not recognized as a valid legal document, although practitioners use them as it allows you to put forth your wishes and guide physicians and any decision makers, whether it be your healthcare proxy or power of attorney, for making those medical decisions on your behalf. So a real life example would be, you have while some states do recognize these as an absolute legal document, in Massachusetts, if you had one, they would use it as deference to supplement any decision that the doctor would make or your healthcare agent could make. Trust. So a big portion of estate planning has to do with trusts. However, I could do my own little presentation here on trust, and the reason I'm just going to kind of graze over this aspect of estate planning is this gets into we get into very murky waters when we start talking about trust, because trusts are specifically crafted for individuals relative to their net worth, income, tax ramifications, not to say the least. So I'm going to kind of give you a brief overview of three of the most common trusts: revocable trusts, irrevocable trusts, and testamentary trusts. However, if you want any specific questions relative to these three, how they interplay with estate plans, I ask you reach out to me again directly so we can go over that. Mainly because what I found in doing these in other settings, when you start asking questions relative to trust, it gets very confusing, and it's hard to answer your question without having a full encapsulation of your net worth and what your goal is for creating any trust document. So again, I'm going to go over these three. These are in no way exhaustive. There are other forms of trusts that you can use, but these are the three you have most commonly heard of and are most commonly used when crafting an estate plan. So you have your revocable trust, is also known as a living trust. The grantor or donor can retain control of the assets while they are alive and do what they wish with those assets. So when you have a revocable trust, you can also maintain yourself as a trustee, and you can make amendments while you were living. And it contains instructions relative to distribution of assets upon the death of and will list the beneficiaries of the trust upon the death of the original donor or grantor or trustee. So it's a good form to use if you want to get something, put something into a trust during your lifetime. And again, we're going to go over this, but anything you put in trust and fund during your lifetime. So if it's put into a trust property, so if your property is the situs of a trust, which means it's the property of a trust, again, that's a non-probate asset, so it's a non-probate property. But that's can use some further flushing out, which again you can do on a more one-to-one basis with your estate planning professional.
And Rob, I have a question here, and again, this might be one-to-one, but is there a benefit to having a revocable trust as the benefactor for life insurance policy, the husband and wife only trustees? Does that make sense? It might be line.
Yeah. So basically that's routinely used if you have minor children and you want a revocable trust. And also what you typically see is some estate planning practitioners will use a pour over provision in a will, and allow you to pour all your assets into that trust as well. But basically, to the pointed question, if you do that, it allows for the life insurance policy, if it goes into the trust, to be distributed by the terms of the trust. Again, whether it be to a minor child, it becomes trust situs, and then that property, which would be a payout of a life insurance if husband or wife were to pass away, will be distributed by that trust.
Thank you.
So again, like I said, just a general rule for all these trusts: hold your assets outside of your probate estate, so your distributions are made directly to beneficiaries without the need for probate to be filed. If the trust situs is made during your lifetime, that's not applicable if you have a testamentary trust. You can also, again, I just actually touched on this via our question right there. You can craft a will to include a pour over provision that pours over or directs your assets to a revocable trust for estate administration purposes. And basically what that does is, if you do that within your will, it allows for a more streamlined probate process. Irrevocable trusts, these are what you'll see. I get more calls, inquiries about these than anything else. An irrevocable trust basically is a trust that cannot be amended or revoked once established. You cannot access or control your assets, as those duties are in the hands of a trustee. So you name someone who you know, like, and trust to act as trustee of whatever the trust situs will be or whatever the trust property will be. Irrevocable trust can be used to address specific situations such as Medicaid, eligibility and planning, and gifting for future generations. They're often used as a means of asset protection, and you will hear people talking about them, and the big one's going to be, well, I want to avoid my nursing home touching my assets. That's when you'll hear irrevocable trust coming up the most. And they're typically used by those who are seeking to also kind of limit their estate tax exposure. With Massachusetts, it's 1 million. Federal is going to be 11.7 million. But an overarching issue or this is, if you have heard the term irrevocable trust, or you think it applies to you, again, a lot of people who have a good amount of accumulated wealth are going to be thinking this way. reach out to your estate planning attorney directly, because they're intricate, they're involved, and they take a lot of not only legal advice but tax advising as well. So it's make sure you get your proper attorney and a proper CPA, and as well as there are attorneys who do both and have their LLM, which is their master's in tax law. And then the last one I wanted to just briefly go over is just a testamentary trust. It's created in a will. The pro of a testamentary trust is it's relatively inexpensive because it's actually created within the will that you're already doing up for your estate plan. The con is it allows that probate. It's going to be subject to the probate process. So testamentary trusts will only be funded if the probate is instituted. But the reason people like them is if they have a modest estate, but they want to make sure that their minor children are protected, they can use a testamentary trust to be operable only upon the scenario by which their youngest child has not reached the age of majority, which is 18. Again, they're commonly used in basic estate plans as an economical way to go about crafting an estate plan for, again, modest estate. And I don't say modest estate meaning it in a bad way. I would say, again, 80% of the people I talk to have what I would qualify as a modest estate. So we'll go over that. And again, just to brush on a couple of things I had jotted down here. So a lot of people will say, well, what about other sorts of trusts? I heard people talk about, what about a nominee realty trust? Well, a nominee realty trust will be the same thing as a revocable trust. It allows someone to hold their real estate in trust to be devised to their successor trustees or successor beneficiaries upon their death. Again, what does that do? You deed your real estate into a realty trust, and then upon your death, the only thing that your the contingent beneficiaries, which are typically, say, for instance, mom and dad have a real estate trust to their house in Reading. Mom passes away first, dad second. Dad's the remaining trustee. Upon dad's death, it goes to the three kids. What you do in that scenario is if the trust is held, if the property is held by a real estate trust, in order to sell that property, it would be relatively easy. You record a death certificate for the father. You have to record a state tax release or a state tax affidavit if it's not taxable, and then the trustees, which would be the successor trustees, which could be child A, B, and C, or child A, or whatever it is, can thereby sell that property by simply recording a trustee certificate, a deed, and again, that death certificate. So that's another very common one you'll hear. It's not up there, but someone had asked me a question about that before I had come on tonight, so I figured I'd just talk about it very briefly. And again, that's a very inexpensive way to effectuate non-probate transfer of your real estate. And in 8 out of 10 scenarios, people's real estate, especially towards the end of their life, it's going to be their biggest asset. Identifying probate and non-probate property. So people always ask, well, what's probate? What's not probate? Well, anything you own that's held jointly, if it passed by operation of law from one owner to another, it's going to be a non-probatable asset. What does that mean? I have a life insurance policy. Well, if your life insurance policy has a designated beneficiary on it, it's not subject to the probate process. It can be considered in calculating estate taxes, but it's not going to be subject to the probate process. So what I tell people all the time, and what I see time in and time out, so if you're watching this, if you're older, or if you have older parents, make sure that they're updating their life insurance policies, especially their designees upon the death, because what will happen is mom and dad will have one. Mom will list dad, dad will list mom. Mom passes first, dad gets the life insurance policy, dad doesn't do anything, dad passes away, and he has no other assets. He had deeded out his property, he had got rid of everything else. Well, that life insurance policy, if mom, who's predeceased him, is still on it, that lapses back into the estate. So you're gonna have to open a probate just to deal with that asset. So in Massachusetts too, if your estate's valued under $25,000, there's a streamlined process for probate administration. But your typical life insurance policy, I should say typical, or what I see as a typical life insurance policy, is much more than $25,000. So you are actually opening an estate with the probate court just to deal with that. It's also a very common thing with stocks, believe it or not. People who have stocks, especially if they're older, So if it's someone's parents, grandparents, great grandparents, the stocks will be the only thing that lapses back into their estate, and they end up coming. I had just recently done an estate where somebody had $50,000 of Disney stock, and that's what happened is they bought it a long time ago, and they just never did anything with it. And they list there, I think it was husband and wife, wife to husband, and they predeceased. One predeceased the other, so you had probated for that. So again, that's a very common thing. Any jointly held property you have, which we've already touched upon, bank accounts, whether it's husband and wife, whether it's another very typical thing is you have elderly parents. They list one of their kids as a TOD beneficiary, which means transfer on death. So if your parents, say mom and dad, have a bank account, they list, John Smith. So they have 3 kids, but they list John Smith as a TOD beneficiary. You have to make sure they know what they're doing, because when they pass away, that property goes to John Smith, brother, not to the 3 kids. It's whoever you're listing as your TOD beneficiary on that account passes wholly outside the probate process. So again, mom and dad pass away having 3 kids, and they only name one as their transfer on death beneficiary. The kid, that one child's going to get it. I cannot tell you how many times I've heard mom and dad say, well, we're going to do that, and John's going to do the right thing, and he's going to give it to his siblings. Well, that's great to think about, but it's not always the case. So you have to, that's a big thing to consider when you're talking about what you want to do for your estate planning. Do you want to have it? You can create one of those trusts we said, or so on and so forth, or do you just name your 3 kids in equal shares, so they have to make sure that they all 3 can get it and they want to close out the account. So that's something to think about when you're practically planning estate planning. And again, retirement plans, anything any retirement vehicle you use, this is better suited to direct towards your financial advisor, your wealth advisor. Say, hey, am I up to date on all my designated beneficiaries and all these accounts? Because if something happens to me, I want to make sure that my whoever I have is gonna get it outside the probate process. And if husband and wife, wife to husband, or somebody had predeceased me, I want to make sure that I update that and make sure they have those are to date, year over year or every couple of years, or again, in the change of life circumstances, you're changing those. And the last but not least, any any property put in trust prior to the decedent passing away. So if it's funded, if the trust situs is funded during the decedent's lifetime, not a testamentary trust, again, that's going to be non-probate and pass outside of the probate process. What's next? So it's basically it's kind of what I tell people if they come in for an initial consult, like, what's next? Well, if you have an estate plan, when's the last time you reviewed it? Have you had any change in circumstances? A big one, marriage, kids, something along those lines. Or if not, what are you waiting for? The typical answer is, I don't want to talk about, and it's okay to think this way too, is I don't want to talk about death. I don't like talking about death. It's not my cup of tea. Well, everyone that comes into my office and sits at a conference room table, when you have to talk to someone about dying, it's an emotional process. But it's unfortunately taking the human element. It's not a good reason to delay this process, because what you're doing is because you don't want to talk about it now. If you don't go about taking these steps now, you're actually you're causing pain, suffering to your loved ones on the back end. So while I understand and I have some empathy towards someone who say, well, I don't like talking about it. It makes me very uncomfortable. I no doubt that it does, but it's going to make your loved ones more uncomfortable if they have to go take care of any of these scenarios which we've gone over, and they have to go about doing it that way. So if the answer to that question is, why I feel uncomfortable, I guess my only advice would be, everyone feels uncomfortable. So talk to friends, family, call a couple estate planning attorneys, get comfortable with somebody. Don't just go, you can't just go in and have it be robotic, because you're not going to have a good experience. And quite frankly, the more robotic interaction, you might go in, set everything up, and you'll never sign it. And again, that's not just for non-robotic. A lot of people, and I shouldn't say a lot, there are some people who will meet with me, who have an estate plan, and then they'll just never come and sign it. And something will happen to them, or they'll come back in 3 years and say, hey, I'm ready to sign it. Well, yeah, now I got to get it out of storage. Obviously we haven't printed it yet, and you do all that stuff. So to that second question, what are you waiting for? If the answer is you're just uncomfortable talking about it, you don't think you need it. Um, if you're over the age of 18, or if you're tuning in tonight and you have kids, you definitely do. So why don't you should be taking those steps now, or at least if you're not going to go through with it, at least just start the process, meet with somebody, sit down, talk about it. And we went over some things tonight you can do even before that. Check your bank accounts, check your designated beneficiaries and all those accounts. Those are steps you can take on your own. And then your next step could be seeing an estate planning professional. And again, that brings us to a second, what's next? Have you checked your beneficiary designations to date? I always suggest people do this year over year or every couple of years if you let it slip. And again, the biggest thing to do is talk to your financial advisor, your wealth advisor, if you have one, and say, hey, I'm up to date on these things, right? On my life insurance policies, all that stuff, and put a bug in the ear to make sure that they don't forget. Or and even if you have elderly parents or just older people, if you know someone who passed away, hey, mom passed away 2 or 3 years ago. You updated your beneficiary designation on anything you might need at bank accounts, life insurance policies, right? And that's a good way to think about it, and it'll also get you thinking about any change of circumstance, and again, what you need to do relative to your estate plan.
I have a question here. So in order to find the best match for me, I'm just using their words, but in order to find the best match for me and my family, what questions should I ask a potential estate attorney before getting started with that person or in getting started in that process?
Yeah, it's more along the lines of just make sure that whoever you're going to can handle what you're going to bring. Um, I can tell you that it would be a pretty much a non-starter for me if somebody, and this is just I'm talking about just at a more macro level, um, who you should be narrowing your search to. If someone said, "Oh, I'm worth $25 million," I'd say that's awesome. Would love to work for you, but I don't think I'm going to be the right guy because I think you're going to need some very complicated tax planning to reduce all those estate taxes you're going to have owed. So you should be seeing, and then I have a bunch of people I refer those kind of estates to. But on a more micro level, just reach out to somebody, talk with them over the phone, have a discussion with them, and they should be asking the questions. Well, it shouldn't be, this is what I think you should do. It should be, well, the questions coming from an attorney should be, well, what do you want? What are your goals? And then they should try to be telling you what they can do for you. It shouldn't be right out of the gate, well, you need A, B, C, and D. It should be, it's intake first, then legal advice. So you tell me when someone calls me, they tell me what they need. They kind of give me they kind of talk about the basics of their estate or accumulated wealth, or whatever you want to call it. And then I kind of say, well, this is the steps you should take. And you call around a couple different people and just talk to the person that you're going to be actually dealing with. Although I can tell you it's hard to get an attorney on the phone when you're trying to schedule those interviews. But most of them, again, will offer free consultation, at least to get you in the door to try to make sure you're choosing the right person.
And this kind of goes hand in hand. Another question that had popped up earlier was in terms of, do you practice in New Hampshire? You need to have a lawyer that is practicing, an attorney that's practicing where you reside? How does that work?
Yeah, so I don't practice in New Hampshire, so you should, because if that's a more involved question if you have property that kind of goes across through different states. But the general rule of thumb should be if you are a New Hampshire resident, you should have a New Hampshire attorney going through your estate planning process with you, because that's where a vast majority of your assets are going to lie. And they're going to know exactly how to advise you relative to devising any of the specific requests you're going to make relative to property, whether it be real or personal.
Okay, great.
And any other questions, Jen? If you have any questions that you would want to ask, I'd be more than happy to entertain those as well.
I have a whole lot of my own, but that's for another time.
Yeah.
No, it looks like we touched on all of the questions as they were coming up, which was great. We were able
Okay.
to incorporate those in there. But as you said, I'm sure folks can reach out to you. Your information is up on the screen. So for anybody who is looking for an attorney here in Massachusetts, your information is there, and we'll make sure that these slides and this video it is being recorded, so we'll make sure that this is accessible through our Austin Prep website as well. Anything more from you? Great stuff, Rob. That one came in from Joey Carrigill.
Thanks, Joe. I really appreciate it. I'll be expecting your call tomorrow, Joe. Actually, one more thing, Jen. We talked about this, and I don't want to forget it. I believe someone had asked a question before about if somebody passes away, when the time frame you have to actually
Yes.
file their probate.
Yes.
So, as I told you before, loaded question. So the general rule of thumb. So with the MUPC, we kind of divided up into pre-March 2000, March 31st, 2012, post-March 31st, 2012, to when the decedent died. So without knowing the specifics, I'm just going to operate as if we're talking about somebody who died post-2012. You have 3 years from the date of death to get that filed. However, after that time frame, the MUPC, Massachusetts again, allows you to file what's called the late and limited testacy, and so you can still file the estate. However, you're limited to what you can do with the real property. It basically it limits what the personal representative has authoritatively and what they can do with that the property, whether it be real or personal. So again, it is that statute of limitations, and if it's pre MUPC enactment, which would be 2012, March 31st, 2012, there is a whole other way to go about it. But the answer is, if you have specific property that needs to be dealt with, there's going to be an avenue to deal with it. But the general rule is going to be the 3 years.
Thank you. Thank you for bringing that up again. I had it on my radar and I passed right by it.
No problem.
All right. Well, I thank you again so much for sharing your time and your expertise in this area with all of us. We'll look forward to having you back on campus again when it's safe to do so, and another career day, or maybe virtually in a classroom at some point this year. So
I'm always here.
I love it. Thank you. So I just want to let our viewers know that our next webinar in the Austin Prep Presents series is going to be a cooking demo. It's a family-friendly Super Bowl party menu, and it's going to be with class of 1996 chef Peter Agostinelli, who is the culinary director at La Belle Winery up in New Hampshire, and Todd Moriarty, who is the director of dining services here at Sage Dining at Austin Prep. So Chef Peter's going to be walking Todd through creating several family-friendly recipes that folks will be able to have at their Super Bowl parties. And he's going to be here in the dining hall at Austin Prep preparing this menu. So it's kind of amazing. So we will be sending out a link via email, and it will be on our website for you to be able to access that. That one will be a pre-taped webinar. So, so again, thank you everyone. And for other webinars, please feel free to visit our Austin Prep website, the alumni section there, as well as on our social media pages, Facebook, Instagram, Twitter, LinkedIn. And again, thank you, Rob. It was wonderful having you.
Thank you.
Enjoy some snow out there.
I will. Thanks.
All right.
Thank you, everybody. Bye-bye.